Well, good afternoon, everyone. Hello. My name is Angela Reilly. I am broadcasting here from Los Angeles, and I'm delighted to have this amazing panel of speakers here with me today. I want to acknowledge the Tongva peoples, who are the people of the land here, and thank them for letting us be on this land today. Before I introduce the panelists formally, I'd like to start by turning this over to Professor Jennifer Dennetdale, who has been gracious enough to say a few words to get us started in the right way. Professor?
All right, thank you, Angela. I'd like to just briefly introduce myself. My name is Jennifer Denetdale. I am Toga, born for Ashia, and my maternal grandparents are Kitlichitni, and my maternal grandparents are Kitlichitni, and my paternal grandparents are Tuahedlini. So what and I asked Professor Reilly if we could begin with just a few words regarding this panel and the subject topic. This morning I offered a prayer. I went out and offered a prayer because this topic that we're going to be talking about is a very difficult one for the Navajo people. Being a commissioner on the Navajo Nation Human Rights Commission, we just recently completed a study on Navajo funerary studies, Navajo funerary practices, and it was very difficult to talk about this topic that's related to death and violence and death. And so I offered a prayer and asked that we offer our words in good faith and with good mindset and intentions, and that we do this on behalf of our respective Indigenous nations and communities, and hope that our words will open up space to think about liberation and justice. And so that's all I wanted to offer. Thank you.
Thank you so much for that. Well, let me get us started. I'll just say a little bit. I'm going to share my screen here for a second, just so we can properly introduce our panelists. So my name is Angela Reilly. I'm a professor of law at UCLA School of Law, and I direct our Native Nations Law and Policy Center. I'm a citizen of the Potawatomi Nation in Oklahoma, and I'm delighted to have you all here for this event today. I want to just start by giving brief introductions of our panelists. They all have incredibly impressive bios that are lengthy that you can read about, but I want to give them more time to speak. So I'll give brief introductions, and then we'll turn it over to Delegate Slater, who will get us started. Let me just start by introducing our panelists. First, we have, as you've already been briefly introduced to, Professor Jennifer Dennetdale, who's a citizen of the Navajo Nation. She's a historian and a professor of American Studies and director of UNM's Institute for American Indian Research at the University of New Mexico. She served on the Navajo Nation Human Rights Commission for 9 years and has served as its chair for 4 years, from 2016 to 2020. She received her PhD in history from Northern Arizona University and is the author of 3 Navajo histories and numerous articles and essays. She's the first Dene to receive a PhD in history and is the recipient of many awards for her scholarship and advocacy. Next is Matthew Fletcher. Matthew Fletcher is professor of law and director of the Indigenous Law and Policy Center at Michigan State University. Professor Fletcher sits as an appellate judge for several tribes. He is a citizen of the Grand Traverse Band of Ottawa and Chippewa Indians. He's a prolific writer. I can't possibly keep up with everything that he does. He's a prolific writer of treatises, case books, and articles, and many of you may know him as the author of the leading blog on American Indian law and policy, Turtle Talk. Next, Professor Addie Rolnick. She's a professor of law at the University of Nevada, Las Vegas. She teaches Indian law, criminal law, critical race theory, and others. Before joining UNLV, she was the inaugural Critical Race Studies Fellow at UCLA. She's represented tribal governments as an attorney and a lobbyist with Sinoski, and worked as a legislative drafting consultant to tribal governments as well. And her research focuses heavily on criminal justice in Indian country, including equal protection and juvenile rights. And we're also delighted to join here today Carl Slater as a delegate. Delegate Slater was born and raised in Washington, D.C., but spent a lot of his childhood in Round Rock, Arizona with his grandparents. After his graduation from Colorado College, Slater served in positions in the Navajo Department of Transportation as Senior Public Information Officer, Manager of the Airplane Department, and as the Communication Director for Speaker Seth Damon before being sworn in as the Navajo Nation Council Delegate in October 2019. So we are honored and delighted to have our speakers here. And I'm sorry I didn't advance through the slides as I talked about how amazing they all are. I just wanted to say a couple of words about the case, and then I'm going to turn this over to Delegate Slater, who's going to open our discussion. I'll be very brief because I know many of you out there are familiar with this case. As Professor Dennetdale said, this involves issues of great gravity for the Navajo Nation and for other Native people around the United States and around the world. This is a case that involved a conviction of Lezmond Mitchell and an accomplice of murder of 2 citizens during a carjacking that happened in October of 2001. And the legal issue that has been raised so prominently recently is that the United States could bring this prosecution under the Major Crimes Act, but would not have been able to pursue the death penalty without the consent of the Navajo Nation. And the Navajo Nation did not give its consent for the death penalty and opposes the death penalty. But as a result of this, the prosecutors instead charged Mitchell for carjacking resulting in death, which got around the Major Crimes Act and the consent requirement. And Mitchell was in fact executed by the United States last month on August 26th. So I'm going to stop sharing my screen now so that you can see our speakers. And I'm going to turn this over now to Delegate Slater, if you'll begin for us. Thank you so much.
Unmute. Okay. Yeah, thank you very much. I'm going to introduce myself. Yat Eshakedo Shadane, Adone Nishnagi, Kiani, Nana, She Sontane, Bashachint, and Najini Dashacher, Sontane, Dashanella, She Carl Russell Slater, Dashajane, Tsenek Anate, Nasha. My name is Carl Russell Slater. I'm Kiani, born for the Jewish people. And as you heard, I grew up between the Navajo Nation and the Washington, D.C. area. And I think that that's benefited my lens of analysis on how justice issues are handled off the reservation and on the reservation, and broadened my perspective to what's possible. Acknowledging the facts of the crimes that were committed is incredibly important, and centering the victims and their surviving family members, I think, needs to be the first and foremost concern. And in this process of trying to explain the Navajo Nation's position to our people, in addition to external actors, that message was lost. And I'm here to share that with you, that people felt that the nation was standing up for a murderer and was not standing up on a set of principles that long predate the actions of this crime, or the crimes that were committed and his alleged involvement. But, that is one concern. This was I would say, a very traumatic, reinvigorated a lot of traumatic memories on the nation. The district that I represent includes where the vehicles were found and where some of the crimes may have been committed. The case against Mr. Mitchell, I know that you didn't explain this in the explanation, but there was actually collaboration between the federal government and the tribal government to obtain these alleged confessions that never were written and signed by Mr. Mitchell's own hand. And in his only recorded interrogation, he vehemently denies connection with the capital offenses. So, it's more than just that the federal government made a commitment to the Navajo Nation and Indian tribes across the board. It's that the nation is consenting to a process and saying that we agree with this process of circumventing the laws as they apply to non-Indians so that we can catch our own people in these loopholes. And that is not what we need to stand up for as the Navajo Nation. So this spirited debate came to the council. I sponsored legislation that would affirm that the nation does not believe in the death penalty for any of its citizens, and that in this specific instance, we do not agree that the U.S. government should be applying the death penalty to Mr. Mitchell. So in the course of that debate, pretty much all of my colleagues who spoke agreed with the legislation. And I was really taken aback thinking that some of these maybe more conservative or hardliner type folks, you know, would be the hell and brimstone, you know, chop off their legs and feet and head and whatever. But no, what they were saying is, look, we need to have a holistic approach to justice matters, that we need to look at what the households were like for people, you know, who get caught in the justice system. We need to, of course, you know, center the victims and their rights. And the current conception of justice in the Western sense, as applied by the U.S. government, has a horrible history as applied to Indians, B, a horrible history as applied to the Navajo people, and C, that capital offenses or its utility as a deterrence or as a tool of justice that will yield a more enlightened and better and more civil society is really mixed. And so, I mean, at best it's mixed, right? And at worst, it's just a tool of white supremacy and colonization to continue that colonial project on Navajo. And when we go back into that conversation of what does it look like? What did justice look like either pre-contact or when we were in, you know, I don't know, I'm sure Dr. Denetdale could articulately explain this, but say, you know, in the 19th century where we have a lot more interactions with the Mexicans, with the Spanish and the Mexicans, and then the US government finally in this territory of New Mexico, you know, what did justice look like then? And I can tell you what justice looked like just right after the treaties. And that was one of our leaders, Barboncito. I mean, I think a lot of people are familiar with these sort of it was the Navajo Nation witch hunt that went forth. But we know what the effect was. Okay, maybe there were witches, whatever. I'm not going to speculate on that right now. But I do know that the people who were executed by our leader were those who were expressing reservations and hesitancy to re-engage with the government and the leadership that was identified by the federal government as the only appropriate either chiefs or negotiators, et cetera. So when we have the federal government tightly involved with our leadership, and then our leadership exacting capital punishment against our own leaders, our local leaders, the ones who traditionally held the most amount of power, not some centralized authority up here. I guess it's appropriate, I'm holding this right in front of the seal. That it turns out that they were all executed, or many of them were executed as a deterrence, and the effect was consolidating that colonial political control with the chosen entity of the federal government on Navajo, and that was these certain leaders. And that's not to knock anything that they did on behalf of the Navajo people, the accommodations, the negotiations, all of those things. But you can have strong leadership who articulates your interests before the federal government well, who is constantly trying to improve the lives of your citizens. But when it comes to these justice matters, maybe we're just coming in to fulfill the furtherance of this colonial project. So, you know, my goal as a delegate and as a leader of the Navajo Nation is to help get us to the point where if the federal government ceased to exist tomorrow, or say they gave us all of our land back, you know, in full control over it, would we be able to actually administer ourselves and self-rule? And the answer right now is no, because we have an executive branch that only spent $5 out of $714 million of CARES Act funding as of this past Friday. So if we can't even spend money on our healthcare, we certainly can't handle all these other issues. But our obligation as leadership is to get us to that point. So it's to re-examine how we did justice prior to contact, whether those are appropriate today, what we need to modernize, and then how we can assert full control, absolute and full control over every type of justice matter on the Navajo Nation, whether it's civil, criminal, whether it's between non-Indians and Indians who aren't members of the tribe, or it's between our own citizens on our land, as it was in this matter. So I know I was all over the place there. I really appreciate the opportunity to speak here. And yeah.
Thank you so much, Delegate Slater. We really appreciate you providing those words and putting things in context. We'll have more opportunity to exchange dialogue, hopefully, during the Q&A. I want to turn now to Professor Rolnick, who is going to give us some of the doctrinal ins and outs of exactly how criminal jurisdiction works in Indian country, and how this doctrinal framework produced the results that we saw in this case. So Professor Rolnick.
Thank you. So I'm going to try to address kind of three questions really quickly. One is, how did this happen, right? So that's the legal explanation for, especially if the Navajo Nation's opposition to the outcome in this case was so clear, how does it happen that it doesn't matter legally? And then the second question is, why doesn't that answer it? So why is it still a problem, even if the kind of doctrinal answer is one way? And then third, I want to say a couple of things about why I think this this story is particularly important, but I guess I do want to begin by just saying it's a hard case to talk about. We've all mentioned it, so it involves death, right? So we're talking about a case in which there was a lot of advocacy for the reasons that we're discussing against the imposition of the death penalty, and then it was carried out, so that's already happened. And it's also hard because it's a big crime, right? So we have the death of the person who was the defendant, Mr. Mitchell, in the case, but we also, you know, the story starts with an earlier death. So those are always difficult to talk about. And that's just sort of the nature of major crime prosecutions. So it's a hard context. I'm gonna kind of stick to the laws for a minute. So how did it happen? So there's a kind of an easy doctrinal answer to it, but it's worth explaining a bit. So the federal government has limited criminal jurisdiction. That's the first thing. They don't just get to enact criminal laws about everything. And so the federal death penalty doesn't apply to that many cases. There are a couple of reasons that the federal law can apply and that the federal government would be able to impose the death penalty that are relevant to this case. So one context is that there's federal jurisdiction over crimes that occur in what's called Indian country. And so that is federal territorial jurisdiction over land that is understood as being federal land. And there's a set of criminal laws that govern because of territory. But there's also a set of what I would call general federal crimes. So we don't talk about them in Indian law classes as much, but the federal government also has jurisdiction over crimes that are federal crimes anyway. And so the justification for federal jurisdiction, you need a separate constitutional justification for each extension of federal jurisdiction. And in that case, the justification is something different. It's not based on the territory that is being governed. It's not based on federal territorial power. It's based on usually the commerce power, right? So the idea that the crime somehow affects interstate commerce. So if it was a normal murder, just a standard murder happening on a reservation that is counted as Indian country, then that would be under federal jurisdiction because of the Indian country criminal laws. So the basic laws there are the Major Crimes Act and the General Crimes Act or the Interracial Crimes Act. These are two very old laws that say that there's federal jurisdiction over crimes committed by Indians against non-Indians or vice versa. And then only a few crimes, only major crimes committed by Indians against other Indians. That's the rules. And so generally murder is a major crime. So if you have an Indian defendant and an Indian victim, then it gets to be in federal court because of where it happened, because of the Indian country crime laws, because of the Major Crimes Act. But this, there's also a federal carjacking law, and the federal carjacking law is not, it makes a murder a capital crime, not because of where it happens, but because carjacking, for reasons that I won't go into now, affects interstate commerce somehow. And so that's a totally different basis. So legally, the way that this gets to the question comes up and the way that we have the problem that we have in terms of sovereignty is that the prosecution happened under the other kind of federal crime, not the Indian country crime. Now, there is a law, the Federal Death Penalty Act, in which the federal government and Congress enacted certain crimes that were capital crimes. And then it says in it, but you can't impose the death penalty, we can't impose the death penalty if the tribe doesn't agree in cases where the jurisdiction arises because of the territory. So that would have covered it if it was a regular murder prosecution under the Major Crimes Act. But because it's pursued under the carjacking law instead, and that's where the capital crime comes in, then the prosecutor gets to ignore that language. So I might suggest that sometimes those languages in federal laws are sloppy. I don't know that it's totally clear that they meant to limit it that much. Sometimes the exemptions for Indian country crimes are not drawn correctly, maybe because the drafters don't quite realize how broad it should be. But all that to say, the law is what it is, which is if it arose under a regular murder statute based on territory, the nation's view would have been dispositive. It's only because it was prosecuted under another statute that it's not. So, okay, the second question is, why doesn't that answer everything? So why is that not the end of it? Why is there then no problem? So the problem is really that it violates the entire policy and spirit of what the federal government has been doing with regard to criminal jurisdiction and tribes for the last, I don't know, 40 or so years at least. So I would divide that period into, so there's an earlier era in which the federal government is extending jurisdiction into Indian country without really caring about what happens to tribes or tribal jurisdiction. But beginning in the self-determination era, so in 1968 at least, what we see is the federal government trying to bolster tribal courts. There's a series of statutes enacted in which what Congress is trying to do is to help tribal courts take more authority over different matters, to give resources to tribal courts, to support them, to train them, and the idea that tribes should be carrying out justice in the way that they see fit. And the Congress is marshaling its money to support that in a series of statutes during the 1968 to 2000-ish era. Now, in that era, tribal jurisdiction stays the same. So they don't touch the scope of what tribes can do, and they don't try to roll back what Congress can do. They're just bolstering tribal justice systems. But that's clearly what Congress is doing, and there's no exception that I'm aware of. So that's when they enact the Federal Death Penalty Act, with this exception for tribes being able to say what happens. That's when they enact other laws that create exceptions for tribes being able to say what happens in federal court. And then after 2000, I think there's another turn, right? So then what you see is statutes that expand tribal jurisdiction, right? So the courts have already been strengthened. The Congress is expanding in certain areas the jurisdiction of tribes to do things that they maybe weren't recognized as being able to do before, and starting to roll back what the federal and state governments can do, where it's inhibiting what tribes can do. So the problem here, and the Congress is starting to see it, is that when the federal or the state government can prosecute something that happens on tribal land, even if the tribe is allowed to prosecute it, they can totally undercut, as happened in this case, what the tribe wants to do. So if a tribe wants to prosecute someone and do something that is more what we call restorative or rehabilitative, and then the federal government comes in and prosecutes also and sends them to prison somewhere, you can't do both of those things. You can't rehabilitate and restore someone who's in another state in a prison. So those two things are sort of undercutting each other, even though they're both legal. So Congress starts to see that and starts to kind of push back at what the federal government can allow to do. So it's small. A couple of examples are the Tribal Law and Order Act, Section 221, which allows, where there's state jurisdiction under Public Law 280, it sort of allows the tribes to petition to bring back federal jurisdiction because that's what the tribes think is better suited. So this is deferring to the tribe to be able to dictate what situation is going to be best for law enforcement there, marshaling state and federal power to help them as opposed to being under them. There's also requirements of things like data sharing about when prosecutions are declined, and sharing data that comes from investigations. So there's an increasing desire by Congress to try to get the federal and state governments not out of the game entirely, but to marshal those resources so that they support what tribes are doing instead of trying to undercut what tribes are doing. And so in this era, I think if you look at all of those kinds of laws together, the way that I would describe them, sorry, I just want to read something to you because it's better than what it is I'm saying, is that they demonstrate that Congress is acknowledging that strengthening and supporting tribal justice systems requires an expansion of tribal jurisdiction to restore diminished sovereignty, but also limiting the exercise of federal and state jurisdiction to ensure the exercise of another government's jurisdiction is not undermining tribal sovereignty. So that's important. And that's, again, consistently what Congress has been doing at least since 2000. So the problem here is that the Federal Death Penalty Act's exception for these other kinds of crimes prosecuted in Indian country looks like an accident now, because it's totally out of line with what Congress is trying to do otherwise in terms of recognizing that tribes get to have a say in what it is that happens to people where crimes are committed on their land. And it's a kind of a loophole that maybe Congress hasn't gotten to the point of fixing yet. So although the letter of the law supports it, it's completely out of line with the spirit of what's happened since 2000 and also since 1968 in terms of very clear federal policy for supporting tribal sovereignty in the area of criminal justice. So the last thing I want to say is that this is also, I think, a really important moment when we think of criminal cases that arise in Indian country. So a lot of times in a lot of the historical cases, the defendant is an Indian person and the tribal sovereignty win, right? So the tribe's position and the way that you would uphold tribal sovereignty is something that screws over the Indian defendant. And so there's a lot of those cases, a lot of the major criminal jurisdiction cases, they uphold tribal power at the expense of what is happening to actual Indian people who are the criminal defendants. So it doesn't always go well for them. And in this case, what you see is tribal sovereignty, the Navajo Nation's tribal sovereignty marshaled kind of in support of a criminal defendant. And that is somewhat new in terms of the way that the cases are usually positioned, and I think it's important. And it's in line with, I think, what happened in the killing of L'Oreal Sinigini that I know Professor Dennetdale and all the people at UNM have done a lot of work on. And the idea that sovereignty can actually support the rights of defendants if tribes are able to control what it is that's happening.
Great, thank you, Professor Rolnick, for that overview. I know we're going to have some questions about some of the details, but thank you for the doctrinal framework. I now want to turn to Professor Matthew Fletcher, who wants to talk, or who will talk a little bit about the role of the death penalty, sort of from a high-level view in general, and its role in criminal jurisdiction in Indian country specifically. So, Professor Fletcher.
Thank you very much, Angela. Professor Reilly. So I'm going to talk a little bit about how the larger history of federal Indian law, particularly criminal jurisdiction, has been affected by sort of famous and not so famous capital cases. And what's interesting in this case, and I think throughout the history of Indian country capital crimes and the death penalty, is that the cases are never really about the death penalty on their face, but many of them absolutely are about the death penalty. So the first case that I'm aware of that reached the Supreme Court of a capital crime out of Indian country is a case that involves a guy from the Cherokee Nation of Georgia called George Tassel, or occasionally Corn Tassels. And he was prosecuted by the state of Georgia in 1831 for a murder that occurred on the reservation. And those of you who know anything about Indian law know that states generally don't get to prosecute Indian crimes in Indian country, especially in 1831. And so the Supreme Court decided to hear that case to assess a much larger question, whether tribal sovereignty is protected under federal law from state interventions. And the state of Georgia mooted that case by executing Corn Tassels upon the receipt of an order from the Supreme Court to respond to a briefing schedule. So this case is inherently, uniquely, I think, very political. And the death penalty, for me, my understanding is that it's also very political. Fast forward a few decades and you hear another case that's more famous, where you have a written opinion, ex parte Crow Dog. Again, very political, an Indian on Indian crime in Indian country. The federal government, for explicit political reasons, sought to prosecute Crow Dog, and the Supreme Court said, no, you're not authorized to do that under then federal statutes. We shortly get the Major Crimes Act after that. And so you will start to see more federal criminal cases involving the death penalty. Actually, you see one right, if you look at my screen, the second on the left, it's kind of like Hollywood Squares, and then there's only 6. The middle on the left is a federal crime. The one on the bottom is Deadwood. I think that is also a federal crime. I think these are inherently political cases. Here's some more just over the years. You find a lot of cases going all the way back. Taya Miles, who teaches at Harvard, did a book on history in Detroit about slavery, and wrote extensively on the murder involved from 1763, which is referenced again in the second, is in the middle on the left. So there's a long history of crimes committed in Indian country and or outside of Indian country by Indian people that have led to death penalty cases. That if you read, I just did a search of cases through the historical archives and newspapers, and you see a lot of very uniquely political cases. So, I skipped over the 1862 mass execution, again, uniquely political at Fort Snelling of 38 Dakota Indians. Very much a intensely political decision that went directly through the Attorney General of the United States and also the President of the United States. And I was pleased to hear Delegate Slater talk about the history of tribal executions of their own citizens. So in the late 19th century, you get Talton versus Mays from the Supreme Court, which doesn't appear to be all that much of a political case in any meaningful way, but is a case that did reach the Supreme Court on the question of whether a tribe had the power to prosecute and execute its own citizens. And just as an aside, I think there's an open question as to whether or not Bob Talton is actually a white guy. If you look on the screen on the left in the article from 1893, the Tyrone Daily Herald, his initial execution date was pushed back and postponed on the question of whether or not the Cherokee Nation could actually execute an adopted citizen, and it says that he is a white man. I don't know if that's actually the case. These are just old newspaper articles, but I thought that was kind of interesting. I'm going to show you a few other, on the right, you'll see some other instances where tribes, mostly in Oklahoma, had a robust criminal justice system in the latter half of the 19th century, and newspaper articles of Indian people being executed by their tribes, Seminole, Creek, Cherokee. Let's go to the late 1980s and early 90s. This is where we get the Death Penalty Act, the Federal Death Penalty Act of 1994. It was under a lot of consideration by Congress for several years under multiple presidents. On the left, you see when it was, an earlier version of it was first introduced into Congress in the late 80s, in the first Bush administration. I thought it was interesting that news coverage of the Federal Death Penalty Act was being caricatured as the Indian Death Penalty Act of 1989. And as the work of Tova Indrich, who I believe is one of our participants today, or one of our visitors today, is showed that back in those days, and this is probably still true, that 2/3 or 3/4 of all federal executions were of Indian people. And you see at the bottom that as a result of some of the work that Native American Rights Fund and National Congress of American Indians did, you'll see that Congress did enact the opt-out provision. That's 18 U.S.C. 3598, and down on the left you'll see the language for that. I've looked at this a couple of times, and I'm still baffled as to how the Ninth Circuit thought that it was acceptable to go through the Federal Death Penalty Act. The phrase in the middle of 3598 says, any offense, the federal jurisdiction for which is predicated solely on Indian country. There's no doubt in anybody's mind that if this crime had occurred on lands outside of the Navajo Nation within the state of Arizona, the state of Arizona would have prosecuted this case. The only reason this case was prosecuted federally was because it was Indian country. Nonetheless, you have what you have. There's some historical legislative history on the right. I thought was kind of interesting. From 1991, you'll see that the current Attorney General of the United States was in front of Congress a couple of different times in 1991 defending what would later on become the Federal Death Penalty Act. He was asked by Senator from Wisconsin, Senator Sensenbrenner, a senator from, well, is that a senator or a representative? Excuse me, representatives. I apologize, they're not senators yet. Representative from Wisconsin and representative from California about the problem of disproportionality of the application of the death penalty to Indian people. As you can well imagine, the Attorney General then and the Attorney General now really could just give a shit about that, and completely agreed at the bottom, in particular in the colloquy with Senator Schiff. Yeah, it's likely that they are going to be subjected to the death penalty under this rule, and admitted that as well with Sensenbrenner. And here are some of the testimony from the tribes. You see Native American Rights Fund's testimony. I believe that Tova Indrich did some work on that, giving us some data. The middle screen on the left, you'll see some lengthy excerpt of the testimony from the Navajo Nation in 1991. And you'll see the ACLU at the bottom talking about how Congress has spoken on the policy question and was confused as to why it was still coming up. I wanted to highlight that much of my own knowledge of this case comes from Tamara Begay, one of my former students, who is a Navajo Nation member and did scholarly research on this question as a student on this case, and helped me out in putting together an op-ed for the Atlantic magazine. I wanted to conclude by just saying that I come here not as a death penalty scholar, not really as a criminal justice scholar, and not a Navajo Nation citizen, but it's apparent to me, and has been since I was a small person, that the death penalty is horrendously unconstitutional under any notion of fair play under the United States Constitution. It is also apparent to me that it is used for explicitly political purposes. Our man here, who was executed in August, is really in some ways a victim of timing, given that his crime occurred within a few weeks of 9/11, at a time when the president and the attorney general were trying to show toughness on crime, a response to a massive crime that they were completely flat-footed on, and charged cases with charged crimes as capital cases for the explicit purpose of showing to the American public that they were going to be tough on crime. That didn't last very long. You know, the informal moratorium on federal execution started up just a year or so later after the conviction of our guy here. And the only reason, and any of us have followed this case, that that he ultimately was executed in 2020 is for pretty much the same political reasons. We're in a state of national crisis about the roles and the goals of criminal jurisdiction throughout the United States. One political party has chosen to be the party of law and order, the party of capital punishment, and politically chose to resurrect the federal death penalty for overtly political purposes. And it's apparent to me that this, on so many levels, just one, the general unconstitutionality of the death penalty; two, the way that it is applied to Native people in the United States at a disproportionate amount; and three, the political purposes under which all of this happened is really quite disturbing. I'm aware from hearing from Delegate Slater and others, Tova Indritz, Tamara Begay, that there are enormous problems with the conviction of our guy here, as well as the question of jury selection in Indian country, or the lack thereof. Native people are almost never on federal juries, although ironically there was a Native person on this jury. It's quite possibly only the second or third time I've heard of a jury in a significant federal prosecution where there was actually a Native person on that jury. So I'll conclude with that, and I'm happy to answer any questions. As you may have seen from the chat, you can get a copy of this little comic book on Turtle Talk. Any questions?
Thank you so much, Professor Fletcher. That I was about to ask you where I can get a copy of that. So thank you for putting that in the chat. That's some incredible historical documentation. And thank you for giving us the broad overview. Our final speaker will anchor the panel, and that is Professor Jennifer Dennetdale, who's also a Navajo Nation citizen, and will speak a little bit about Navajo Nation perspectives and Navajo human rights. Professor Dennetdale. You're still muted.
Okay, I want to thank the panel for bringing some light to me on this issue. I followed Delegate Slater's legislation and some of the writing and opinions he put out there in public, and I'm pleased to say that I'm on the same side as Delegate Slater. It's very, very difficult to bring forth our opposition to the U.S. enacting the death penalty on one of our citizens for a number of reasons. I did write an opinion piece, which was published in the Navajo Times, and it's in the hard copy. And one of the reasons why I wrote this piece was just because I was hearing what our citizens and our people in our communities were saying, and they were very adamant and insisted upon U.S. justice for Mitchell. And so in my opinion piece, one of the things there's several things that I talked about, and one of the reasons why I wrote this was because many of our citizens don't understand that under the U.S. occupation, the Navajo Nation has lost its jurisdiction to carry out its own justice on cases like Mitchell's. In fact, the Navajo Nation's justice system is so constrained by the U.S. rule of law that on our land, we experience patriarchal violence that has become the normal of our lives. Violent crimes that are more frequent on our nations are actually the consequences of the Southern nations' constructed relationship with Indigenous nations, and indifferent and callous relationship on the US's part, which has meant crimes can be committed on Navajo land with impunity. Our people experience violations with little hope of resolutions, and certainly not toward the constantly desired hopes of healing. For healing cannot begin when the federal government is the perpetrator of violence against Indigenous people and the worst violator of human rights. The US carrying out the death penalty on a Dene affirms its authority as the arbiter of who will die. The federal government under this pro-death penalty president has now carried out more executions in 2020 than it had in the previous 56 years combined. And for me, what was important was the question about how our own people have little knowledge or appreciation for the fact that Dene had a justice system and carried out its own sentences. And Slater mentioned the cases that are most visible in colonial archives, and that's the one about execution of witches. So the Navajo people, some of them told me that the execution of Mitchell will send the message to criminals that we have strong laws. In fact, the message is that the US will continue to tell the Navajo Nation what justice looks like. And one of the things, when I think about these issues that I read and follow up, I think about the long-term vision. I think about what is it that we want and what does justice look like for Dene and for Indigenous people? What do we imagine when we think about liberation? We should be reminded that what is seen as our own lawlessness actually was contained to a great degree, because as land-based and matrilineal people, we once had community and kinship ties so strong that we took care of each other, and such crimes as Mitchell's were not ordinary. Okay, and so my work and my research really brings me back to thinking about transformation really means returning to community-based care and the strengthening of network matrilineal-based clanships as ways to support, as ways to defend. And so that's just kind of what I bring to this panel. Thank you.
Thank you so much, Professor, and I really appreciate that perspective. I think I have somebody helping me go through the questions, but I don't have them in front of me yet, so I'll take the prerogative to give one of my own. I think, one of the maybe obvious components of this discussion is to think about how sovereignty works, how tribal sovereignty works on the ground with regard to criminal jurisdiction, among other things, and how the interplay between sovereigns works. I think, one question I have been curious about with regard to this particular case, but sort of more generally, and all of your presentations actually alluded to this to some extent, is to think about, whether and to what extent there is cooperation between sovereign governments and whether and to what extent that's desirable. And I don't know, Delegate Slater, if that's something you want to speak to start us off, but, as an official of the nation, I'm curious, how much cooperation there is in terms of, as Professor Rolnick said, kind of harnessing resources and bolstering sovereigns as opposed to trying to undercut one another. And of course, I'd love for all of you to answer as well. Thanks.
Are you talking about the sentencing phase, or in the investigation, or after, or like in the last month or so, or 2 months?
Yes, but really all of it. I'm curious in terms of when there's going to be a prosecution, collaborating or deciding between a tribal prosecution and a federal, one or the other, or both, or some to run subsequent to one another, etc. Yeah, thanks.
I mean, this should have been a tribal prosecution, full stop. I mean, I know I'm speaking to a bunch of lawyers and this is a law school program, but forget that. Forget what you know in the legal profession. Your gut tells you that if this is this people's government, then we should be the ones who should have delivered justice. And I think that that's where we need to start. There's a lot of abstractions that come from this case about, we were talking about the doctrinal issues, all of these things, but ultimately, everyone involved is a citizen of the Navajo Nation, and the Navajo Nation exists, and we should have had the power to deliver justice. So when we talk about the collaboration between, or whatever the relationship is between the federal government and the Navajo Nation, BIA funds the majority of the justice services that are delivered on the Navajo Nation and the Department of Justice. It's not Indigenous funding. It's not funding that we are able to provide ourselves, because we're now tasked with participating in this economic system that isn't set up for success on the Navajo Nation within our traditional homelands, unless you're a foreign corporation taking coal or oil out of the ground. So what is required is resources that should come from the federal government to help support this justice system that they require of us, right? If you're going to have any sort of jurisdiction over white people, over non-Navajos, we need to be a part of that process and understand what your laws are, and are they okay? Is there due process? All these things. Once, their involvement, the federal government is triggered. And so when we talk about that vision of where we're trying to go, let's set all that aside for a second and say, the Navajo Nation needs to be able to self-determine our justice system. I don't have that answer right now about what the appropriate response would have been at the time. But us making that decision ourselves is number one. So the federal government has to fund these sorts of justice services. We do need, I'd say, policing. Maybe it's not police, but there are bad people here. There are bad people everywhere. We need to be able to defend ourselves in our communities. A lot of them have weapons and operate and do things that ordinary people shouldn't be asked to do. So I guess to come back in at the end, the Navajo Nation, just like any tribe today, right, knows how to work the federal system. We have lobbyists. We have a Washington office. We have connections to the White House now, apparently. And through the efforts of the last few months and things that I tried to raise with our president, our vice president, other people, we were able to communicate with senators, with the president's staff, with the vice president's staff. They knew what was going to happen, and they let it happen. That's ultimately what happened. But I'm going to tell you, it's no secret who the Navajo Nation's champion was in this case, and it was Martha McSally. So this issue, I think, has a broader appeal than just, okay, is the Democrats working with the Indians? It's that if there is going to be a sort of self-sufficient Navajo Nation that somehow coexists with the states and the federal government, we're going to really need to have our own justice system, because otherwise we're going to be a second-rate sovereign. So can I just mention one more thing, though, about that justice system? So, we did have communal sorts of justice systems, and it wasn't 100% uniform, even community to community for certain crimes. But the one constant was that you would have interventions in people's life well before you get to this stage, well before you have someone who's getting involved in gang activity, someone who's hanging around with the wrong guy, someone who's drinking, was on I think a 3 or 4 day, drug and alcohol induced binge, clearly was psychotic at the time of the crime. We wouldn't be at that stage here. A lot of the things that are front loaded in dealing with community members and from a justice perspective were harsher, right? I mean, it could be something as simple as you're 5 years old, you don't get to ride your horse for a month. You look at a 5-year-old, it's like, maybe, that's going to scar that kid. But all of these little pieces on these interventions, these communal connections, the restoration of the spirit and trying to create citizens who can contribute positively to their family and obligations, that existed. And we don't have that full replacement now in this justice system. So it's giving the power back to Navajo to decide for ourselves. And you know what? Maybe very well he should have been executed, but executed by Navajo hands. And those people who were commenting on Facebook saying, you know, this has nothing to do with me and let's kill this guy. And, you know, I have full faith in the federal government to administer justice. You know, I come from another tradition too, right? And I say that I'm born for the Jewish people. I grew up in that, studying how the death penalty was expounded upon and how sacred it is that life is. And there were preconditions, right? That the people, the witnesses who would contribute to that death penalty had to be the first ones to cast the stones or whatever under certain rabbinic literature. So that informs me too. If we're going to take this on as a nation and as a people, we have to live with the moral repercussions that exist. We are not the Denetdale, we are not God. We don't understand and control everything. And to believe that we have the power to administer that in a godlike or deity-like fashion is, I think, a usurpation. But ultimately, we have to live with each other. And if we decide that someone shouldn't be a part of our community, then maybe all the options have to be on the table. But that needs to be a community decision and not, you know, Bill Barr and this death cult of, you know, an administration and federal government.
Thank you very much. Do any of the other panelists want to speak at all to the tribal federal dynamic?
Can I?
Of course.
So, because you asked a question in the middle of your question, which was, does cooperation between governments happen in prosecutions and should it? And I guess I would like to disaggregate that. There's two questions there. So one is, should tribes be required to cooperate with other jurisdictions? And the other is, should the federal and state governments be required to cooperate with tribes? And I think that they raise different questions because the governments are situated differently. Sometimes cooperation happens, but right now, as a matter of what the federal and states are bound by, the federal government and the state governments, there is no requirement that they cooperate, or there are very few. And my view is fairly strong here that when it comes to the question of whether other governments who are not the tribe and are involved should have to cooperate with the tribe, the answer has to strongly be yes. So it is of course true that the tribe needs to be able to, like every nation needs to have its own system that it administers, but that's asking a lot given the history of what has happened to tribal justice systems and what criminal justice has to look like today, to just sort of say, do it on your own. So there is a need sometimes for resources from the state or assistance from federal investigators. And I don't think tribes should be prohibited from asking for that on the idea that it would undercut all of the things that they want to do. So those other governments that come in to help should be required to take a cue from what it is that the tribe wants to do in terms of what both the sentence and kind of the way that the case is prosecuted. And so Delegate Slater mentioned the problem of, normally, historically, this would have not gotten here because there would have been intervention earlier, but this problem of not requiring cooperation is a problem all through. So my favorite example, besides the Death Penalty Act, of where this happens is juvenile prosecutions. So the federal government recognizes that generally it shouldn't be in the business of prosecuting juveniles. So for all states, the only way that the federal government, even if it's a federal crime, the only way they prosecute juveniles is if the state says, we don't want to prosecute this kid. We don't have the resources and we'd like you to do it. So you have to have state waiver, state consent every time. For tribes, what the law says is that you just ask the state, and the state says, well, it happened on a reservation, we don't want to prosecute this kid. They never have to ask the tribe. So they might if it's a particularly nice prosecutor, but there's nothing in the law that says they have to, which means that if there was a desire to say, you can't ride your horse for a while after you made this mistake, at the level of the tribal justice system, the federal government is free to come in and say, but we're going to send you to South Dakota to prison for a while, because that's what we're doing. And then there's no way to carry out what it is the tribe wants to do. So there's not much in the law, and Congress, I think, is starting since 2000 to correct this, to try to nudge the other governments into sort of paying attention to what the tribe wants, but they really haven't fixed most of it. So mostly in the law, you have no requirement, and we're just relying on good prosecutors and good relationships. That's really different, I think, than the question of whether or not the tribe should be forced to cooperate with the federal and state governments, because the tribe is the primary sovereign here. So whether or not other governments are involved, they're the one that has the primary responsibility for justice in that community. So they should be the one that comes first. And I don't think that the same question comes up when asking if they should have to cooperate with outside prosecutors.
Great, thank you. Well, to build off of that, so to keep that question sort of on the table for my other two panelists if they'd like to speak, but also to build off of it, there's also a question for sort of thinking about more of the community role in this, and all of these, your comments have sort of led us in that direction. So I guess as part of the question of tribal sovereignty and the relationship with the federal government is a necessary predicate question, which is what is the role of the community in advancing its own standards and with regard to criminal jurisdiction and public safety and community values. I don't know, Professor Dennetdale or Fletcher, if either of you want to speak to that.
This is Jennifer. I don't have a whole lot of faith in justice systems, whether it be the US justice system or the tribal courts. I think that there has to be a vision that really moves responsibility and accountability to our citizens, to thinking through what matrilineal-based networks look like, and so, I don't know what they look like. I think that we have to imagine what that looked like, because primarily they were protection for elders, for women, for children. And so it's not the justice system is not going to fix it, particularly because tribal court systems are pretty much operate the way the imposition of justice systems have worked. Right now we have a case that I've been following in Shiprock. There's just on the ground huge agitation regarding hemp farm operations. And I'm seeing our leaders' response is to start criminalizing, and that's a Western patriarchal colonial kind of response of justice system. So I think we have a really long ways to go.
I'd like to add on to what Dr. Dennetdale said. There's going to be a reckoning in Indian country that's going to happen sooner or later. In this case, we're talking about trying to limit federal criminal jurisdiction, criminal prosecutorial authority. In other cases, like the one in Oklahoma, Sharp and McGirt, we're trying to limit state authority and turn it over to the federal government. We've got a strong push, a powerful grassroots push for a more criminal jurisdiction authority with tribes and the federal government to deal with missing and murder Indigenous women. And I really want to support what Dr. Dennetdale said about not trusting and not having enough faith in our criminal justice systems, federal, state, and tribal. Around the country, you're seeing a push towards racial justice and prosecutorial decision-making, policing decisions, judicial decisions about prosecutorial and police discretion. And I think that some of those issues may come up in Indian country. They tend to be more federal. They tend to be cases that reach the Supreme Court. If you're going to have a big case about qualified immunity involving the police, it wouldn't surprise me a bit if it had something to do with a federal and tribal law enforcement team cooperating with each other, playing with the Indian Bill of Rights, playing with the US Constitution to play the little game that they did in the case involving our guy here today. These are incredibly complex questions, and I throw my hands up. I started at the beginning and said I'm not really a criminal justice guy, but I think we all have to be going forward if we're going to be involved in work in Indian country, advocacy work, scholarly work. This is really where the future is. Tribes have an enormous opportunity, and have had that opportunity really since the beginning of the self-determination era, to decide how they want to deal with criminal justice themselves, for at least the cases that they have power over. Yes, someone's going to come along once in a while, the federal government, and is going to pull a trick and execute somebody or send them to South Dakota, as Professor Rolnick was saying. You can't take care of all of those cases, but what amazes me is that tribes have fundamentally failed in so many levels to reassess what criminal justice means for their tribal community. So I was really grateful that Professor Reilly asked the question, what do the communities have to say? I would love to hear more tribes like Navajo ask the community. And I know that the answers are not easy, but I was really pleased to see that in the early 2000s, when our guy was being prosecuted, the Navajo Nation went to the community and asked the questions. You know, should we support as a nation the execution or the potential execution of one of our citizens? And the community seemed to say no. And that's ended up being the nation's position in that case. But I just think that there's a reckoning that is absolutely going to have to happen. It's happening nationally to some extent, but I think Indian country also has to address it in a fundamental way.
Thank you. Professor Dennetdale, did you have a response to that? I wasn't sure if you were trying to get in there.
Oh, no, I wasn't.
Okay. Well, I guess we don't have a lot of time left, but I did want to just ask another question that also builds on the questions in the queue. And it relates to, I guess there's sort of a couple of things, but one is kind of thinking about what would a next step look like. And you all have kind of identified critiques, but also all sort of talked about optimistically about next steps and what they might look like. And I guess I ask that, and then I also just want to tie another question. So I guess it's an and or, which is to say, we all know that there are gaps that are happening. Even though there may not be actual legal gaps, that there are gaps in criminal justice in Indian country as there are in other places in the United States. Part of it is because of breakdown of community fabric. Part of it is breakdown of resources around non-punitive measures, community-based advocacy, and other possibilities. So I guess, and then some of them are just doctrinal problems, as I think both Professor Fletcher and Rolnick both alluded to, which are, how does the Indian Civil Rights Act come into play here, and how is that going to work with regard to, let's say, the right to counsel, for example, which I know is a question that people have been paying attention to and was an issue in this case. So I'm kind of throwing a lot at you, but I'm going to say question mark if anybody wants to pick up on any of those issues.
So I will, and I don't, partly this is picking up off of the last couple of Professor Fletcher and Dennetdale's comments in going to your what's the next step question. So it sometimes, some of the answers I think are easy, right? So if the question is what you asked before, should the federal government and the state government be required to defer to the tribe when trying to figure out what it is that happens? The answer is an easy yes, and there's some places that should be fixed in the statutes, and there's not really much more to say about it, I don't think. But it is much harder than that, because then if, the more power tribes have, the more it's up to those communities where the crimes happen to kind of figure out what happens. And then there's a lot more to say then, right? So the question of power over your criminal justice system is one thing. The question of how you wield that power is a totally different one. And it's complicated, but I guess it's even more complicated than that. So what I've found is that I'm surprised often by how readily I've seen officials in tribal justice systems and tribal government officials adopt narratives about criminal justice that sort of come from other people. So narratives about gang crime, and narratives about immigrants, and narratives about the need for the death penalty and punishment, that I can sort of trace those, and they don't necessarily seem to be connected to anything that's happening in that community. So just to give you an example, I used to represent tribes who were lobbying the Bureau to try to get funding for justice facilities. That was one of the things that I did. And I really was struck because at the time, the funding was only for jails. So the regulations and the grants only allowed for the building of jails. It didn't allow for the building of court buildings. And so you'd have a set of council people that came in and they would say they wanted a court system and they want a building that has one cell, but mostly they want to do all this other stuff. And then the answer is, well, you can't do that. You can only build something that's a jail. And then they'll come back and sort of say, okay, then we want a jail. And then I would hear people talk about just, we really do need to have more jails because there are, Mexican drug dealers coming in and marrying people, and then there's all this crime, and then we really do need to put people in jail. And then the same person would say in a different place when we were talking a story about how their nephew was getting involved in the justice system, and they were really sympathetic because that kid had a bad home life. And so you could hear when they're talking about their people, you could hear them understanding and wanting to kind of have a more understanding approach. And then they would just turn around and say something that didn't match that at all. And I guess what I was struck by is how much people didn't realize that they were doing that. And so I look more closely at juvenile systems, but what I've watched is that I will talk to, so every administrator of a jail for kids on a reservation, every single one that I've ever talked to, cares about the kids and talks about how much, they're always men, how much he cares about the kids. And it sounds good, but they also run a jail. And it is very much a jail, and they have like restraints and tiny handcuffs and boards where they tie the kids up. And so it's like one set of things that people are saying is very much in tune with this idea that justice should look different. And then you see, without realizing it often, governments and officials kind of carrying out a justice that looks like a total blueprint. And some of this I think has to do with the way that funding has been leveraged so that you don't have control over what kind of thing you build. But also I think, as to what Professor Fletcher said about how we have to all be criminal justice experts in a way, like it is an insufficient interrogation of what criminal justice should look like. And it's just a kind of an adopting of whatever it is that everybody is saying about crime being bad. And that until that is better interrogated, you'll hear people say traditional justice is better and then carry out something that looks totally different and not even realize that.
Thank you. Would my other panelists like to respond to that question? And or in our remaining few minutes, do you have any final words you'd like to share on anything related to this conversation?
I'm a politician, so I always have something to say. Learned that pretty quickly. I think I'll be in office as of a year on October 10th. Something that I share with people a lot is that I don't know how to say this, it's difficult for me to talk about, but I'm not a Navajo supremacist, I'm not a Diné supremacist, but I think that the Navajo Nation government and our people have an obligation to actualize and enact in this world part of the philosophy that in our ideas of being that come from our deities and from the Denetdale. And that is about restoring, whenever there's disruption, the parties or the state of beings of the world into that sort of balance and beauty and harmony of Hajon. And that is what, at the most elemental level, I think our job should be in any situation. So the schism, or whatever we're going to say, in tribal justice systems is reflective of, I think, the federal government and state governments. Do we have a punitive system or do we have a rehabilitative system? What is it in this country? I think, and you can see some of each. You can definitely see the punitive side, right? So we've taken that on, just as was mentioned before. And instead, it's like, set justice aside. What Dr. Dennetdale was talking about, I think, really was a broader set of governance ideas and how do we organize at the local community level for prosperity, and a part of that prosperity is safety. But the prosperity is self-defined. It's not about the endless growth required of capitalism. It's about how do we live in balance with the land, the resources that we have available to us, that were gifted to us by our deities. And so if you set aside all the laws and you just start with that principle, how do we create communal prosperity? Well, it should be sustainable. It needs a safe community in which to operate, whether it's just a matter of leaving farm implements out or ensuring that kids can get to school safely. And if you start with that vision, then I think it's easy to fill in the pieces. But where it gets difficult is negotiating between the traditional concepts and some of the Western concepts. How can I ask someone who is Christian to participate in traditional peacemaking process that might be outside of the Navajo Nation government. It might just be with the traditional actors, right? With a Hatathli or a local headman or respected leader, you know, maybe some uncles in the family, whatever it is. You know, those are the questions that I don't have the answer for right now. And something when we say, what is the next step? I think that is it. You know, it's that constantly defining what we want to be first of all, and then how do we fit in the relationships with the others that we have to coexist with, like the federal government and the states. So, you know, I'm kind of going to leave you on that point, and I just ask that people consider that point. We do have a diversity of religions, of character traits, all sorts of things on Navajo. And the same principles that inform my views as a Natani, as a leader, of that everybody should be viewed equitably by their government, that they should have equal access to their leadership, that everyone's concerns should carry equal weight within their community, mean that I have to take in consideration those whom I don't have the same value system with. And I don't think our people have fully accepted that that sort of negotiation is happening right now. It's always been ongoing, and that we need to level up that conversation and just be very frank about it. Because I can tell you that a lot of the people who were calling for blood were not coming from the Hogan level. They were not coming from my advisors and my practitioners. They weren't coming from the people who are toiling in the cornfields, who are carrying out their traditional way of life with their livestock. They were coming from people who all of a sudden want to carry the weight or carry the water, whatever the expression is, for the federal government. And when did we as a people become those who trust and defer to the federal government on any matter, let alone the decision of whether to wipe from the face of this earth one of our citizens?
Could I just,
yes,
could I just add, I don't know how this fits, but one of my interests in this case is also that I keep in touch with a relative who has serving 4 life sentences. She will not leave the prison walls. She committed incredible, heinous crimes. And I'm the only person who speaks to her consistently. I'm the only person on the outside who supports her financially. And right now she's going through really incredible pain and suffering. She did get COVID. She was in the COVID wing. She spends weeks inside of her prison, inside her cell, because she just, I mean, it's weeks before she goes outside, you know? And so I don't know what to say. I had a Navajo police officer say to me once, if you had seen the scene of the crime, you would not speak to her ever again. You know, and I don't know why I have compassion for her, and that I hope that when she leaves this life, the holy people will embrace her, because the conditions of her life, what happened to her in her life conditioned what happened and what she did, you know. So I just want to add that, and I think about Ruthie Gilmore Wilson's ideas about abolition, and want to get more informed about what she's talking about when she talks about abolition as a way of thinking that seeks to undo prison and punishment as the only solution.
Thank you for those powerful words, Professor. Professor Fletcher, do you have any closing remarks?
Sure. I think that I appreciated Dr. Dennetdale's comment at the very end here. You know, for me, I think there is a solution or a series of solutions we can consider when it comes to criminal justice. And it's like, there are questions that we don't ask. The police and the prosecution usually don't want us to ask. The question usually is, what is it about the person's circumstances, about their life, that helped to contribute to the circumstances that led them to commit this crime? Right. So I don't know what Dr. Dennetdale's cousin did. I don't know why our guy in this case committed these crimes. But it is apparent that a good chunk, a large percentage of crime in the United States is caused by poverty and need, racism, sexism, discrimination on other basis of other immutable characteristics. And none of those questions are relevant in any prosecution. They are not relevant in how the police react to crime. And the police often create crime by showing up to a crime scene, by showing up to the situation and cause people to commit crimes. All of these things are not questions we are allowed to ask in our criminal justice systems from top to bottom. And they are absolutely the sources of the solutions. And I don't want to be that guy who says the police should be social workers. But you know, I don't think the police should be the police either. You know, in our Anishinaabe way of thinking of criminal justice, at least one of the many ways I think that they think of criminal justice, that the Bear Clan, for example, the Muckwa clan, is the internal policing mechanism, but they are also the internal medicine mechanism. They are charged with maintaining the health of the community and preventing crimes. And I think at least some of our presenters today have mentioned that that is really the most important aspect of criminal justice that we, as an American society, flatly refuse to address. And I hope that we can at some point.
Well, thank you so much. We're unfortunately out of time, but I am deeply indebted to you for your brilliance and your service and for taking the time to be here with our audience today. You're all incredible and I'm in awe of you. So Chimegwech, thank you so much. And thank you to our participants for being here. We'll sign off now. Take care, everyone.